Juneteenth illustrates the power of communication and the importance of communication. The Emancipation Proclamation was issued in 1863, but it wasn't until June of 1865 that the word got to Texas. So the question is, what took so long? What's the story behind the story? White Southerners fled to Texas as the South was losing the Civil War, taking tens of thousands of slaves with them. Confederate soldiers in Texas and elsewhere were still fighting for the war after General Robert E. Lee surrendered in Virginia on April 9, 1865. On June 19, 1865, an estimated 6,000 black soldiers of the 13th United States Colored Infantry arrived in Galveston under the command of Major General Gordon Granger. Major Granger delivered to Galveston General Order No. 3. The order informed all Texans that under the Emancipation Proclamation, all slaves were free. It read that the people of Texas are informed that in accordance with a proclamation from the executive of the United States, all slaves are free. This involves an absolute equality of personal rights and rights of property between former masters and slaves, and the connection between them heretofore existing becomes that between employer and hired labor. General Order No. 3 covered an estimated 250,000 enslaved people in Texas. I, like many children of my generation, was taught in school that Lincoln freed the slaves. That was not entirely true, just like Columbus discovered America. The truth? Lincoln freed most slaves with the Emancipation Proclamation, covering about 3.5 million persons of African descent. But the Emancipation Proclamation only applied to the Confederate states in rebellion against the Union. It specifically did not apply to slave states that remained in the Union and certain areas under Union control. 5 slave states remained in the Union, and therefore, there, slavery for about 500,000 people was still legal. In Maryland, Missouri, West Virginia, Delaware, and Kentucky, slavery was legal. President Lincoln was murdered on April 14, 1865, 5 days after the Confederates surrendered in an act of political violence by a white Confederate terrorist. Lincoln died before General Granger got to Texas and before the 13th Amendment, abolishing slavery for the whole country, became the law of the land. By the time the black soldiers arrived in Galveston on June 19, 1865, 3 of the remaining slave states had ended slavery by law. But in Delaware and Kentucky, slavery remained legal until the 13th Amendment took effect on December 15, 1865. So the truth is, the black soldiers actually freed the slaves in Texas. Still, history records that Lincoln's Emancipation Proclamation changed the course of the Civil War and inspired millions of black people to fight for their freedom. The 13th Amendment passed in the United States Senate at Lincoln's urging a few days before he was murdered. In his remarks eulogizing President Lincoln, the great Frederick Douglass pointed out that Lincoln was emphatically the black man's president, the first to show any respect for their rights as men. And that is the true story of Juneteenth. Welcome to Legally Speaking. The 13th Amendment to the U.S. Constitution passed in December of 1865, banning slavery in the United States. But the 13th Amendment left a huge loophole. It banned all slavery and involuntary servitude except as punishment for a crime. Today, California and Texas are among only 15 states that continue to allow the correction systems to use prison labor for pennies. Texas even requires its criminal justice system to use the labor of the prison population as much as possible without pay. California mandates tens of thousands of incarcerated people to work at jobs, many of which they do not choose, ranging from packaging nuts to cooking and cleaning kitchens to making license plates, glasses, sanitizers, road signs, hospital goods, and office furniture for less than 74 cents an hour, according to some legislative summaries. In a state plagued by wildfires, we pay some prison firefighters 34 cents an hour. The law creates a highway for exploitation because if a person does not complete their work or report for work, regardless of illness, injury, or emotional trauma, they face punishment in the form of disciplinary infractions, which can lead to losing privileges, including visits from family members, or having more time added to their sentence. The priority inside prison is free forced labor over rehabilitation. The same or similar rules apply to county jail facilities. In 2024, in a case out of Alameda County, Ruelas versus County of Alameda, the California Supreme Court ruled that people being held in county jails, including people who have not been convicted of any crime, can be forced to work for a private contractor inside the jail for 25 cents an hour or less. The court held that pretrial detainees are not entitled to be paid minimum wage or overtime pay because the county has the right to limit any pay to $2 for 8 hours or 25 cents an hour. In the Ruelas case, none of the plaintiffs have been convicted of any crime. They claim that they were required to work over 40 hours per week, sometimes 6 to 7 days a week for Aramac, a private for-profit corporation without pay. They were responsible for cooking and preparing food, packaging meals, and cleaning the industrial kitchen at Santa Rita County Jail, the sheriff's offices, and other county jail facilities outside of Alameda County. That was what they were actually required to do. The plaintiffs claim that Aramac and Santa Rita jail employees sometimes coerced them to work under the threat of disciplinary measures, including solitary confinement. In fact, under the current law allowing involuntary servitude for prisoners, incarcerated workers contribute billions of dollars every year to prison systems through their labor. And it is legal under the current constitutions in these states. ACA was introduced in the California legislature and passed in 2020 to modify the California Constitution. It became a proposition known as Proposition 6, which California voters rejected in the November 2024 election. Proposition 6 would have prohibited CDCR from disciplining incarcerated persons who refuse a work assignment for good reason. It would have reduced the level of financial exploitation and allowed a person the option to choose between participating in a program for rehabilitation or choosing to work. The California Attorney General's office wrote the ballot language and the summaries for Proposition 6, and the word slavery did not appear on the California ballot. Instead, the language talked about changing the Constitution for incarcerated persons. In this political climate, where vengeance is more important than justice, many advocates saw that language choice as the reason why this ballot measure did not pass in California, the difference between winning and losing. In Nevada in 2024, a measure similar to Proposition 6 passed with voter approval by 60%, but that measure clearly indicated that it was removing the language authorizing slavery using the word slavery. Nevada joined Oregon, Utah, and Alabama, who all recently removed language allowing involuntary servitude from their state constitutions. But it did not pass in California. Clearly, we are on a different page right now. Still, Frederick Douglass's words ring in my ears after the passage of the 13th Amendment. And what he said was, when slavery was first planted in the national soil, treason, rebellion, and assassination were planted with it, and their bloody fruit was bequeathed to the present generation. And if in the coming Reconstruction we shall incorporate any of the seeds of injustice, any of the remains of slavery, we shall repeat the mistake of our fathers with the certainty that our children after us will reap a similar harvest of blood to that which we have just experienced.